Lawyer Baffour is concerned, and his concern is legitimate because we asked him to come and do this. During the vetting, he asked Dominic Ayini, the nominee then, as he then was, nominee for the Attorney General's position. Lawyer Baffour asked him whether the public tribunal conversation in the NDC manifesto was going to see the light of day. During the NDC manifesto, President Mahama promised that what used to be the public tribunal, we're dealing with an audience lawyer tonight who do not really know the history from institutional memory, except those of them who may have read it. But many people don't really know what a public tribunal is. So when you express those concerns at the appointments committee, people didn't quite understand what you were saying. What is the concern? What concern were you drawing attention to?
So the public tribunal system was a parallel, if you like, judicial system that ran side by side the regular courts.
Who introduced it?
It was introduced by President Rawlings.
During the Revolution era?
During the Revolution era, by a law called PNDC Law 78.
What was it, if you like, what was it intended to cure?
The primary function or objective was to reduce delays in our criminal justice administration, because in their view, because of technicalities, there were delays in our justice delivery system, criminal justice delivery system, as a result of which cases took many years, and some people who they considered criminals were never convicted or sentenced, and for, if you like, were not punished.
Somebody also told me that the role of lawyers as barristers was de-emphasized in public tribunal hearings. How was that?
Because, firstly, they were not so big on the procedure.
They didn't like it.
They didn't like procedure. So the fact of interventions by lawyers wasn't much a necessity to them. And so the Ghana Bar Association, for instance, boycotted it.
Okay, lawyers are allowed to appear for clients at public tribunal.
At public tribunal.
But they don't use the procedure of the court.
They don't use the procedure. The rules of evidence were de-emphasized. For instance, you know that for a criminal trial or for any trial, hearsay evidence is not admissible. But there, they would not even...
So somebody can come and say that, I saw you driving a blue car and so, and you have to answer for it.
And you have to answer for it.
At the public tribunal?
At the public
Who was the judge at the public tribunal?
The public tribunal had a lawyer as presiding, as the chairman of the panel.
Is it a judge or just a lawyer?
Just a lawyer.
Any lawyer?
Any lawyer.
Who chooses
a lawyer of not less than 5 years standing.
Not less than 5?
Not less than 5 years standing.
Who chooses that lawyer? Who makes that choice?
Is the PNDC. They had a board. So there was a board of the public tribunals.
The executive?
The executive.
They were choosing the chairman of the tribunal?
So there was a board, a public tribunal board, right, consisting of not less than 5 people and no more than 15 people, constituted by the PNDC. And the chairman of that board was also the chairman of the National Tribunal. So there was a structure.
So who was the chairman? Do you remember anybody?
It was Mr. Ajekum at the time. If my memory serves me right, I think it was Mr. Ajekum at the time. He even was, he appeared before the National Reconciliation Commission.
He was a lawyer?
He was a lawyer.
Okay.
But at any given time, for a hearing, you have 3 members who chair, that is the members of the panel. The chairman is a lawyer of not less than 5 years standing at the bar. But the 2 other persons are not lawyers. And that was a basic infringement on the common law justice administration system. Because under the common law justice administration system, lawyers adjudicate, justice is dispensed with lawyers deciding on matters of law, judges who are trained lawyers deciding on matters of law. And then you have the jury system where non-lawyers will now determine issues of fact. But even that, it will be after the judge, who is a trained lawyer, has explained the law to them. So he guides them
and directed them.
But in this case, the members of the tribunal who were non-lawyers were not only deciding on issues of fact, but they were also deciding on issues of law. That led to a lot of human rights abuses.
Okay, so what is the life of the tribunal? Then what happened? Then John Kufuor becomes president in 2000, and what happens?
When President Kufuor became president in the year 2000, Nana Addo Dankwa Akufo-Addo moved a motion in Parliament to amend the Courts Act, which would repeal the lower levels of the tribunal, that is the Circuit Tribunal and the Community Tribunals. They became repealed by reason of the Courts Amendment Act of 2002. And at that time, the regional tribunal, because of the transition, you know, the national tribunal was not made a feature of our constitution.
Okay, but
the regional tribunal was. But it has never been operationalized.
So that was left in the constitution?
It was still in the constitution, but it was never operationalized. And I can imagine why it was left in the constitution. This was a constitution, very respectfully, that had been the authoring of which, or the promulgation of which, had been supervised by the PNDC, to whom these tribunals were their creation. And so in moving forward, they wanted it to be so much a feature of the new democracy. However, it has never been operationalized for more than 20 years.
Never even in the first 8 years of J.J. Rawlings?
I don't remember.
The first 2 terms of the Constitution?
I don't remember.
Okay, so the lower levels were repealed. So what is being done now? Now that Cabinet has approved. What has Cabinet approved?
Cabinet has approved the reintroduction of the tribunals to deal with galamsey cases.
So it's going to be at a regional level?
We are not sure. The details are not out. But we need to look at whether or not it is going to be the same feature as the past, or we are going to see a more reformed tribunal.
So is it coming as a creation of courts by the Chief Justice, or is it coming as a decision of the Attorney General? How is it coming?
So when you look at the NDC's manifesto, they said that they were going to operationalize the regional tribunal, which is a feature of the Constitution, and then they would also reintroduce the communities and circuit tribunals. That was the NDC's constitution. Okay. Now, if that is what they intend doing, then, of course, with the reintroduction, it may require the amendment of the Courts Act or a passage of the tribunals, a new Tribunals Act, which will come with its own set of rules and procedures.
Can the Chief Justice create new courts and call them tribunals?
The Chief Justice may not be able to. When you look at the Constitution of Ghana, the only time the Chief Justice may be able to do any such thing has to do with the creation of divisions of the High Court. And so, for instance, you know, there was the Fast Track High Court, there was Commercial Court, there's the General Jurisdiction Court. They are all divisions of the High Court. But under the Constitution, if there is going to be, yes, the Constitution allows for the creation of district courts, circuit courts, and lower tribunals. These are all features of the PNDC. They are relics of the PNDC. So don't be surprised they are still in the Constitution, because this is a Constitution which was introduced by the PNDC.